also teaches Florida Con Law for us, an expert on that area and many other areas of the law. I think many of you know Judge Shepard. He's going to give you a 3-hour lecture jam-packed with it. And I really think you're going to get Florida Con Law because it's been missing for a couple of exams. So please pay really close attention. He's going to give you a lot of substance. He's also going to talk to you about how to answer questions on the exam. So without further ado, Judge Shepard.
Thank you, Dean Singer, and thank you all for being here. This afternoon, our plan is to cover all significant areas that you may see on the Florida bar exam in this area, in this field. You should feel free to ask me questions as we go. This is a relatively small group. I'm pleased to respond to any questions. There are 12 articles to the Florida Constitution. And there is a list of all 12 of them. We will spend most of our time on the articles that are highlighted, meaning the Declaration of Rights, the legislative article wherein we'll pick up some pieces of the executive branch. We'll spend quite a bit of time on the judicial branch, finance and taxation, and homestead, which is contained in the miscellaneous article of the Florida Constitution. You should have on your desk a copy of all of these slides and a copy of the Florida Constitution. So please lay them next to each other because we will be going back and forth between the two. In addition, you have on your desk, you have a copy of a handout called Extraordinary Writs. I will spend very little time on it. I will allude to it when we get to that point in the judicial branch, but I will leave it to you primarily to spend such time as you have, because it is an example of something that is less likely to unlikely to be tested. The other handouts are a handout on Homestead by Rowan Kelly. That handout is a good basic layperson's discussion of Homestead, and if you've not studied it previously, it should be especially helpful to you. Another handout is Municipalities in the Florida Constitution by Judge James Wolfe. This piece which should be very useful, and I strongly recommend that you read it after you study Article 7, the Tax and Finance section, because it pulls it all together. It's only about 20 pages. And the last piece, never been tested, so I'm not going to spend any time on it, but in my class, we talk about amending the Constitution, so I'll leave that to you. So that is our introduction, and we shall move forward. First, there is a written, to start with basics, a written separation of powers provision in the Florida Constitution. That provision, Article 2, Section 3, sets forth the branches of government, as you would expect, the executive, legislative, executive, and judicial branches, and says no person belonging to one branch shall exercise any powers pertaining to another branch. The rule, the basic rule with respect to the doctrine of separation of powers, which you need to know, is highlighted there. Comes out of the cases that are listed. And the two basic principles behind the doctrine of separation of powers are, number one, that no branch may delegate its constitutionally assigned power to another branch, and number two, no branch may encroach upon another branch. With respect to the non-delegation doctrine, which I'm sure you're familiar with from constitutional law and perhaps administrative law, with respect to that, the corollary is the legislature can delegate functions so long as there's sufficient guidelines by which a court can determine whether or not the delegated power is being properly and accurately exercised by the branch to which it is delegated, usually the executive branch. The encroachment doctrine, we will see several examples of as the day goes on. And that means that with respect to each of the articles, each of the branches of the Florida Constitution, each of them can act anywhere within their sphere. But if one moves over and moves into the other one, then you have a separation of powers problem. That's the statement of the law. You will see 3 or 4 examples of that as we go. But if you get a Florida constitutional law question on the exam, which is highly likely, then you need to be able to repeat the 2 basic principles there. We now head into the 3 branches of government: the legislative branch, the executive branch, and the judicial branch. With respect to the executive branch, there are 2 basic areas of Article 3. And with respect to Article 3, before we even get to that, if you go to your copy of the Constitution, these sections that you should focus on and understand are sections 6, 8, 10, 11, and 12. If you look at the entire list of the legislative article, however many sections it go, you're going to see things like redistricting and number of judges and things like that. Those are things that are, you just won't, you will not see a redistricting question on a bar exam. The sections to understand are those that I listed: 6, 8, 10, 11, and 12. If you look at the summary or the contents, which I see a couple of you looking at, you'll get a pretty good idea of what that is. Those sections break down into 2 major pieces. One of them is called types of laws, and the other one is the legislative single subject rule. And I'm going to cover each, and I will wind in the additional points that need to be covered as we go. Types of laws. There are in Florida 4 types of laws. 4 types of laws. Court cases challenge laws as being unconstitutional because they do not meet or fall into one of these 4 categories. What are the categories? First, the legislature has the power to pass a general law. What is a general law? A general law is a law that operates universally throughout the state, but does not have to be universal in its application. An example: driver's licenses. There is a general law that says everybody who drives in this state must have a driver's license. However, if you don't have a driver's license, of course you don't drive, you don't have to have a driver's license, so it is not applicable to every individual in the state. It operates throughout the state on everybody, but it is not applicable to every single individual. The other feature of general laws is that there's no notice requirement. The state legislature can pass any type of general policy law that it wishes without giving notice to the population. The legislature meets 60 days a year. It's in session presently and will no doubt pass all sorts of general laws. The second type of law is called special laws. A special law, as you might expect, is one that relates to or is designed to operate upon particular persons, places, or things. These types of laws are sometimes called a local law. A special law and a local law under the law today is exactly the same thing. We usually call them special laws. And the reason we know that's the case is because in Article 12, Section 10, I think it is, I taught it last night. Article 12, Section 10 says that I may be slightly off on my section number, but Article 10, Section 12. Article 10, Section 12, the dean tells me she's now smiling. Article 10, Section 12 says just what I just said, that a local law is a special law. Special laws have more conditions, obviously, on them than general laws. First, a special law cannot pertain to any of the 20 forbidden categories found in Article 3, Section 11A. Please open your Constitution for Article 3, Section 11A. And we will see that there is a list of laws that are prohibited in the special law context. Prohibited special laws.
What section?
Article 3, Section 11 says there shall be no special law, and note, because it is the next point, or general law of local application pertaining to, and there's a whole list of 20 of them: elections, jurisdictions of duty and duties of officers, assessment and collection of taxes, rules of evidence, punishment for crime, change of name, divorce, fishing and hunting, and similar things. That, if you just think about it a second, those are the types of things for which you would not want there to be a special law in this state. You would not want there to be a special law for Pinellas County in divorce or for Hillsborough County in evidence. These are things that these people of this state have said appropriately should have statewide effect. So a special law is a law relating to a particular person, place, or thing. You can have a special law, for example, a case that we talked about last night in class. Some years ago, there was a problem with dogs in some sort in Pinellas County. The legislature passed a special law requiring all dogs in Pinellas County to be vaccinated. That's a special law for a particular person, place, or thing. It was not pertaining to any of those 20 categories. There are additional conditions with respect to the validity of a special law. A special law is not valid unless there is a notice, either a notice to seek enactment thereof in section 15.02 of the Florida statutes lays out what that notice has to be, or alternately, the legislature can place in the proposed special law a provision for a referendum. Unlike a general law, a special law is affecting a particular area, so the conditions are cannot affect any of the 20 forbidden categories. There must be notice in one of two fashions, either notice under section 11.02 of the Florida statutes, which is newspaper notice. Actually, it's been that way a long time. It's not been changed, newspaper notice. Or if you don't do that, we put a referendum provision in the proposed special law so that people that it affects, Pinellas County or the South Florida Water Management District, whatever it may be, can vote yea or nay on it. The third type of law is a general law of local application. This one is tricky. All of these have been tested, by the way, okay? Every single one of these have been tested. So please, if I do this, that means remember it, okay? I know you're going to remember it all, but I can't help myself. This one is tricky. There are general laws of local application. A general law of local application, otherwise called a population act, by which I mean, as I say in class, if you come across a RV question and it has a number in it, i.e., for example, it pertains to this law will be effective only in municipalities of over 500,000 people, your antennae should go up. Everybody's going to remember this, right? I just did it. You're going to remember this in the room. Your antennae should go up. What is the source of general laws of local application? First, they are in fact general laws. The source emanates from Article 3, Section 11B. 11B. And Article 3, Section 11B says in the enactment of general laws on other subjects, means other than the 20, political subdivisions of the state may be classified only on a basis reasonably related to the subject of the law. General laws of local application emanate from that subdivision hidden away in the Florida Constitution. Note that general laws of local application can only pertain to political subdivisions of the state. Every once in a while you'll see a question where a piece of legislation is designed to pertain to the judicial branch, numbers of judges in a circuit or something like that, and maybe giving more judges to circuits that have 2 million people. That is not a general law of local application because the judicial branch is not a political subdivision of the state. However, the main point is anytime you see the number, you ought to be thinking types of laws. Types of laws, and if you see a number in there, general laws of local application. A general law of local application that is designed to operate on a political subdivision of the state, as the provision I just said reads, must be reasonably related to the population classification that is given, 90,000 people, 500,000 people, whatever it is. There are the second qualification found in the Constitution itself is at the top of Article 3, Section 11, as I said already. There shall be no special law or general law of local application pertaining to any of the 20 listed subjects. So you have two constitutional conditions right smack in the text of the Constitution pertaining to the validity or invalidity, as the case may be, of a general law of local application. The third qualification, the population classification must be open-ended, derives from the fact that a general law of local application is a general law. General laws are open-ended. If you take my driver's license example, the general law says that if you are over 16 and want to drive, you must get a driver's license. But you don't have to get a driver's license. You must get a driver's license. So, with respect to general laws, individuals can go in and out of the category of general laws. That is the derivation of the requirement open-ended. So general laws of local application must meet all three of these conditions in order to be valid. I'm going to pause at this point to give a hypothetical. This is a real case. I taught it last night. Mr. Victoria will remember Bessinger versus Pasco County, I think it was. That's the Bessinger case. And I'm going to give you this example because it's something that you can remember. A very good case, by the way, that summarizes all three types of laws that I've just gone over was this McGrath case. It's a fine case out of the Florida Supreme Court. The Bessinger case, okay? In Bessinger, Mr. Bessinger was running a nudist colony in Pasco County, okay? One of the side things in one of the additional benefits of taking my class is that along the way, you learn where all the nudist colonies are in the state of Florida. Is that right? You remember that? Don't you remember? I say it in every class, and it's like an added benefit. Some years ago, the Florida, 1961, not all that long ago by my standards, 1961, the Florida legislature, don't laugh at me. One of my students is in the middle. 1961, the Florida legislature passed a law that said that it is a misdemeanor to operate a nudist colony in any county in the state that had between 36,700 residents and 38,000 residents. As it happens, the only county in the state of Florida at the time that was in that population range was Pasco County. Mr. Bessinger was arrested. He didn't want to go to jail, right? Of course he didn't. And so his lawyer looked at the possible defenses to the case, and one of them that he raised was whether or not this was a valid law. Well, it wasn't the general law, was it? Because it only applied to Pasco County. It might have been, one might argue that it was a special law because it only applied to Pasco County. But if it was a special law, it was equally invalid because there was no notice. So imagine the state of Florida, the prosecutor wanting to put Mr. Bessinger in jail and being challenged on the type of law, saying this is not a type of law that the state of Florida permits. The prosecutor first looked at general law, not a chance. Special law, maybe, but there was no notice, not a chance. Last chance for the prosecutor is general law of local application. If you see a question with the numbers in it, you need to run the general law of local application test. Run it from the bottom. It's the easy way to do it. Run it from the bottom. first thing, you take that particular law about nudist colonies, and you look down the list and see, are nudist colonies listed in the area that says there shall be no special law affecting punishments for crime, evidence, and so on? The answer is no. The answer is no. So far, so good for the prosecutor. Is the population classification open-ended? What that means is, can other counties under this particular statute come into that range and be affected by the law? The answer in the Bessinger case was no. The reason being that the range, 36,700 to 38,000, was stated to be as of the date the law took effect. A little tricky. As of the date the law took effect. It was not open-ended. No other county could ever come in it if it had fewer than 37,500 people or 800 people, and then got up into that area, got up into that range. It was not open-ended. Goes back, emanates from the notion of a general law. And finally, the law, so actually the prosecutor loses right here, but I'm going to run the rest of the test. Was it reasonably related to the population classification? The Florida Supreme Court said no, that there's no reason to have nudist colonies prohibited just in a particular population range. If they wanted to do it, if the legislature wanted to do it, perhaps it might have passed a general law prohibiting nudist colonies in the state, or if it wished to prohibit nudist colonies in a county, perhaps the legislature could have passed a special law prohibiting nudist colonies, let's say in Miami-Dade County, which was the biggest county at the time. Maybe they could justify it as somehow being reasonably related. But if so, that would be a special law, and a special law has to meet a notice requirement, right? So there you have the three main types of laws. If you don't have one of those three, Appropriations Acts are next, and that's a corollary to general laws, but it's a separate category. We're about there. The three are the types of laws, and you will see questions that raise the question. So the question may say that the legislature on such and such a date passed a special law for Volusia County that said can't have dogs over 25 pounds in Volusia County. Okay? And quite apart from whether it's reasonably related, if they gave notice, and it's not within the 20 categories, then it probably passes muster. Appropriation law, okay? Appropriation law. This, if you see it, it'll pop out at you. Okay, the other three, you have to definitely work through. The only thing the Florida legislature has to do every year when it comes into session for its 60-day session is pass an appropriation bill. General Appropriation Act it is called. It is required by Article 7, Section 1C, which says that no money shall be spent from the public treasury except as provided by law. If that doesn't happen, then the government's not going to function beginning July 1 of every year. For our purposes, Appropriation Acts, which text says, laws making appropriations for salaries of public officers and other current expenses of the state shall contain provisions on no other subject. appropriation bills are just that. They are not for making policy. All policy bills are done through general laws, special laws, or general laws of local application. The reason is that you don't want to get into conditions and so on money. It's a constitutional requirement. And what it does is it sets appropriation acts aside from every other type of law. The other important piece of appropriation laws, the other important piece is found, and now I'm going to wind in Article 4, Section 8, the executive branch article. No, I'm still back in Article 3, I'm sorry. Article 3, Section 8, I think it is. 3, Section 8. Every bill passed by the legislature shall be presented to the governor for approval and shall become law if the governor approves and signs it or fails to veto it within 7 consecutive days after presentation. And if that 7th day falls outside the session, the governor gets up to 15 days. So with respect to all of these laws, and it will never happen with respect to Appropriation Act, the governor's right on top of it. With respect to 2 points here, 2 points. With respect to all of these laws, including Appropriations Act, with respect to these laws, the governor has, if the law is passed within 7 days, for example, they just passed some sort of an immigration law up there in Tallahassee, okay, and that was passed. Still, we are presently, we're not even to the middle of the session. That law is going to be presented soon to the governor for signature or not. When that law gets over to the governor's office, because the legislature is in session, the governor will have one of 3 choices. He can sign it, in which case it will become law. The second thing he can do is he can veto it, if he wants to. But if he does neither, this is the important piece, if he does neither, then that, unlike the United States Constitution, where we have a pocket veto, meaning the law is vetoed automatically, it's just the opposite. Just the opposite in Florida. If the governor does nothing, it becomes law. If the president does nothing, it is vetoed automatically, pocket veto. The additional point on Appropriation Act, 2 additional points on Appropriation Acts is they, number one, may not, a particular appropriation, legal lines of things. I mean, the district courts of appeal get $40 million. The Supreme Court gets $10 million. The University of Florida gets $80 million, whatever it is, and so on. These lines. They cannot condition, let's say, the appropriation to the University of Florida or FAU, whatever it is, on some policy condition. The case that we studied last night, and it happened to be the post-secondary education appropriation of whatever of the particular year, and condition the appropriation to each state university on that state university not allowing certain types of groups on campus. Okay? And that is a provision on another subject. There would be an excellent example of that sort of thing. So what happened is that the court would and did in this case just drop out the provision. The other point, that's point number 1 on Appropriation Acts. Point number 2 on Appropriation Act is found in Article 3, Section 12. Article 3, Section 12. it's not in Article 3, Section 12. Article 3. It's in here. I know it's here. There is a provision, come on class members, help me, that says that the governor of the state of Florida has a line item veto over appropriation bills, the General Appropriation Act. It is there, I promise you. I know it's there. Is it Nate still? I'm glad 17. Here it is, yes, I think you're right, ma'am. If during, okay, let's read the 3 sentences, it's worth it. Article 3, Section 8, executive approval and veto. Every bill passed by the legislature shall be presented to the governor for approval and shall become law if the governor approves and signs it or fails to veto it within 7 consecutive days after presentation. We've discussed that. If during that period or on the 7th day the legislature adjourns sine die, that means they're done, okay, final adjournment, or takes a recess of more than 30 days, the governor shall have a total of 15 days from the date of presentation. He gets a little more time. That's not a big deal at all. In all cases except general appropriate, and all, here it is, you're right. In all cases except general appropriation bills, the veto shall extend to the entire bill. The governor may veto any specific appropriation in a general appropriation, but not veto any qualification or restriction without vetoing the Appropriation Act. That last little piece is not policy related. It's has to do with other things. Okay. All right. Let's move on. 10 minutes behind. We're going to move faster. That's not, we'll get there, okay? Single subject rule. The additional requirement for every bill passed, which would apply primarily to general laws, since general laws are the ones where you can have log rolling, is the proposition, the rule is that every law shall agree but one subject matter properly conjuncted therewith, and shall be briefly expressed in the title. Oftentimes, you will see a question where a bar question, this is frequent, a bar question where you'll have some piece of it apply to, say, domestic violence, civil domestic violence, and the other piece of it applied to insurance, something that's two totally different things. The test, what you need to remember is, with respect to the single subject rule, an act may be as broad as the legislature chooses, provided that the matters have a natural and logical connection. Anytime you see a single subject issue, remember that to talk about two things, the single subject rule and the title. Two things, title. Don't forget, because you get extra points for title. The reasons for it are set forth there. No log rolling and giving everybody notice, okay? That's your basic rule for the single subject rule. There's a possible question. All right, so that case there is a summary that you can go read if you wish at some point, and you will see that this particular case combined a civil law and a criminal law. The civil law happened to be a domestic violence law, but it was civil in nature, and the other half of this particular chapter law was a criminal enhancement provision, and the Florida Supreme Court properly found that it affected two subjects and was therefore unconstitutional. We will now go to the judicial branch. something went wrong here. I don't know what. I've always. Yeah. Oh, is that the microphone? I see what that is. Okay, I didn't know what it was. Dragging. I guess I should put that on, huh? Thought it was a tail or something. Yeah. Some of my colleagues would put a tail on me some days, I know. Proud of it sometimes. Okay, the judicial branch. This is obviously important because it's very easy for the testers to put a case, put together a hypothetical around an appeal, which is where you will usually see it. With respect to jurisdiction, we're going to go from the Florida Supreme Court down, but I will tell you right now, please, that we're going to concentrate on appeals. We are not going to spend any time at all on original proceedings, which includes writs of certiorari and the writs that are set forth in the Northcutt piece that I handed out to you, because they are probably never tested, almost never tested, writs not tested. So we're going to stick with this side, but I will alert you to what these are. Appeals. These are taken from final judgments. You know, if they want this recorded, somebody's going to have to come and fix this thing. I don't know what this is all about. Appeals are taken from final judgments and from specified non-final orders. Say again?
You need a flip or something for that?
It has a clip on it.
I'll get the light. Keep going.
All right. Appeals are ordinarily taken from final judgments. You don't get to appeal anytime you don't like something in the middle of the case. There are some specified non-final orders that we'll get to in a moment that are also appealable. Okay. An appeal is mandatory for consideration by the appellate court, whichever appellate court is considering it. In other words, if there's a notice of appeal filed, the courts can't, there's no discretion. The courts have to consider whatever the issues are that are raised. And appeals exist for two reasons. To, number one, review orders for reversible error, legal error, or abuses of discretion by the trial judge. As I said, we will concentrate on appeals starting with the Florida Supreme Court. There are 4 courts in this state, and only 4 courts. We know that because we have looked at Article 5, Section 1 of the Florida Constitution. Article 5, Section 1 of the Florida Constitution says that there shall be only 4 courts, and that they are the Florida Supreme Court, the District Courts of Appeal, Circuit Courts, and County Courts. The next sentence emphatically states, no other court may be formed, period. Read it. A second important point with respect to the jurisdiction of the courts is that it is the Florida Supreme Court. This gets tested. All this gets tested. Otherwise, I wouldn't be talking about it. The Florida Supreme Court is the supervisory court over all 4 of those courts and establishes the rules of procedure in all of those courts. You've probably seen the Florida Rules of Court, a book about this big, and if you flip into it, you'll see the Florida Rules of Civil Procedure, the Florida Rules of Criminal Procedure, the Florida Rules of Family Procedure, the Florida Rules of Probate Procedure, Appellate Procedure, and on and on and on. The provisions, the significant provisions, and the only provisions of Article 5 that you need to spend any time on are Article 5, Sections 1 through 6. The reason for that is when you get into the latter half of Article 5, you get into things like judicial pay and impeachment of judges and all that sort of stuff. You're not going to see that on the exam. We will, as I say, go from top to bottom. The Florida Supreme Court, as I've already alluded to, the Florida Supreme Court is a supervisory court and a court of limited jurisdiction. Limited jurisdiction. Its jurisdiction is set forth in Article 5, Section 3B of the Florida Constitution. It's laid out there in all of its glory. All you have to do is read it and understand it. Because it is a court of limited jurisdiction, the mandatory jurisdiction of the court, which is found in Article 5, Section 3B, 1 and 2, there are only four points of mandatory jurisdiction in the Florida Supreme Court. Very limited. Mandatory jurisdiction, as I said, is appellate jurisdiction where the court in question must consider the case. What are those musts in the Florida Supreme Court? Death penalty cases, for obvious reasons, come directly from the circuit court, skip over district courts of appeal, thankfully for me, and go straight to the Florida Supreme Court from the circuit court. The second category where the Florida Supreme Court has mandatory jurisdiction upon the filing of a notice of appeal are cases in which a district court of appeal, my level court, declares a statute or constitutional provision. Never happened yet. We almost did with the gay rights law, but where a district court of appeal declares a statute, not an ordinance. Ordinances are passed by municipalities. A statute unconstitutional. That goes by notice of appeal. If somebody does it, somebody has to take a notice of appeal, obviously. And the third one are bond validation proceedings. I point that out because we're going to talk about bonds before the day is over. And bond validations are in the list. They're obviously not death penalty cases, but the reason they're in the mandatory jurisdiction list out of the circuit court, they skip over the district courts of appeal also. And the reason for that is not that we're dealing with an individual, but because of the financial markets. Bonds, if bonds is borrowing money, it's like a mortgage, okay? And so, with respect to bonds, those things have to go through. So if Mommy Dade is wants to sell bonds to build parks and all those many things, they have a big bond issue. You want that thing validated before the market fluctuates again. I'll just mention the fourth one are orders of public service of the Public Service Commission, and there's no reason, in my opinion, to remember anything like that. Okay, so there's the mandatory jurisdiction. Because it is a court of limited jurisdiction, and also because it is a supervisory court over all 5 district courts of appeal. There are 5 district courts of appeal with 60 people like me, divided up in the 5 in the state. Because it's a supervisory court, and it's geographic, the court does have an entire list of discretionary jurisdiction that is set forth in Article 5, Section 3B, from subsection 3 on to the end, or near the end. And some of the more important ones are where there is express and direct conflict between a decision of one district court of appeal and the decision of another district court of appeal. Another one that you frequently see are questions of great public importance. There will be occasionally those sorts of things where you just need to know the answer. One that we had the last couple of years was whether or not mens rea was required, knowledge I should say, was required to convict an individual for possession of marijuana, whether you had to prove the person actually knew the white stuff was not marijuana, cocaine. Okay, cocaine, because it doesn't smell. And the question was, do you have to have mens rea, intent? And we said essentially no. Another court said essentially yes. That went up to the Florida Supreme Court. Florida Supreme Court was a lucky day for the 3rd District Court of Appeal, I guess. And Florida Supreme Court said you did not, that there was a general intent, essentially. So these are discretionary writs, express and direct conflict. One court, this happens all the time. Sentencing, the sentencing laws are Byzantine and so on, so those will go up. And you name it, it goes up. The last one I'll just mention in passing is pass-through jurisdiction. That did appear on a bar exam some time back. The question was, what is the fastest way to get whatever the issue was up to the Florida Supreme Court? The example that I will use to illustrate is an election case. If you all followed the 2000 election fracas, you saw that what happened was all DCAs, including mine, we just passed them through, okay? Meaning it had to be something of great public importance and essential to the quick administration of justice. Pass-through jurisdiction, you can look at Article 5, Section 3B, and see the remainder. The only one of these advisory committee opinions that I will mention to you is the second one, opinions requested by the governor. That has been tested. The others have not been tested and I don't think would be. Take a look, pull out your Constitution with me a second if you would, and go to Article 5. Because this is important. This is an important article. We'll tarry just a little bit. Section 1, as I mentioned, is about the courts. The judicial power shall be vested in the Supreme Court, District Courts of Appeal, Circuit Courts, and County Courts. There is, of course, a single Supreme Court. There are 5 District Courts of Appeal. There are 20 circuits divided up by county. Some counties, like Miami-Dade County, is its own circuit. You go up to Pasco County, which is on our mind, I guess. That area has about 5 or 6 counties in the 3rd Circuit, or whatever it is up there. And it says, no other courts may be established by the state. I'm just emphasizing. Section 1C, the one I want to get to now, C. Is it 1C? Yes, I'm in the wrong one. We need to drop back to the executive branch. I'm sorry. I don't want to. Let's just drop back. Okay, Article 4, you're right. I want to point out, I should have done this probably as I was going along, but it's worth dropping back. Article 4, Section 1C. There we go. But this pertains to the judicial branch, obviously. The governor may request in writing the opinion of the justices of the Supreme Court as to the interpretation of any portion of this Constitution upon any question affecting the governor's executive powers. It's limited. He can ask for an advisory opinion. Advisory opinions are not countenanced in our system of justice, but there are a small handful. That's the one to remember. Going back to then Article 5, we have covered mandatory jurisdiction, discretionary jurisdiction. I'm going to leave original jurisdiction to your own devices. Mandatory jurisdiction, we now go to the District Courts of Appeal, the next one down. It's like a pyramid, okay? Obviously things start down in the circuit courts and county courts, and by the time you get up here, it's pretty hard to get to the Florida Supreme Court. The true, nearly final appellate level for this state are the District Courts of Appeal. It's hard to get up above that. Unlike the Florida Supreme Court, which is a supervisory court and a court of limited jurisdiction, the district courts of appeal are your hardworking appellate courts, I'll say. Okay, I don't mean to pat myself on the back, but that's what came to mind. They are error-correcting courts, as distinguished from what I just said about the Florida Supreme Court being a supervisory court and a limited court. You get to come and talk to me for about $300. I think I should raise my rates, right? Meaning you have a right to appeal. You have a right to appeal. Everybody gets one appeal in this country, in this state. One appeal. In Florida, that's in the District Court of Appeal, the intermediate courts, the error-correcting courts. What do we look for? We look for what I've already said. Was there legal error? Or did the court abuse its discretion by letting in some highly inflammatory piece of evidence that he or she should not have done? We don't look and reweigh the facts. That's already happened down there. So the mandatory appellate jurisdiction, what we must do. Of course, all final orders that I told you about, slide number 1, under jurisdiction. I said that there were certain non-final orders, and those have been given to the district courts of appeal under a Florida Rule of Appellate Procedure, and that Florida Rule of Appellate Procedure, and in fact all of the jurisdiction of the district courts of appeal is found in the next section of Article 5. Article 5, Section 4, which lays out the jurisdiction. District courts of appeal shall have jurisdiction to hear appeals. That's what we're talking about. That may be taken as of right. That's what we're talking about. From final judgments and orders of trial courts. And district courts of appeal, where is it? May review interlocutory orders. That's a fancy word for non-final orders. In such cases, to the extent provided by rules adopted by the Florida Supreme Court. There's the rule, 9.130. Here they're not really laid out well. Something happened to the machine. But there's the example of some orders, the more important ones that the Florida Supreme Court has said to the district courts of appeal that they may review by appeal. That means we've got to look at it if there's a notice of appeal filed before the case is at end. Before the case is at an end, and they're pretty much self-explanatory, just like Article 3. Section 11, if you remember, had the list of 20 where you wouldn't want the legislature to be able to have a separate law for evidence or divorce or whatever. The concept is similar here. You wouldn't want a litigant to have to wait to the end of the case to determine whether or not the court that made the decision had the venue to do it. Miami versus Jacksonville, say. Because if you have to wait to the end as the defendant, you probably have, for all practical purposes, don't have any true remedy because you've already been through the process. Personal jurisdiction, same concept. Easier to understand probably. Right to immediate monetary relief or child custody and family matters. In any divorce, the impecunious party is entitled to have some money to fight the battle, and so if he or she is not and somebody else has all the money, you go to court and you'll get an interlocutory order for $50,000, whatever it is. More importantly, in that area, child custody matters. Child custody, as you can imagine, can get very heated in these type cases. you can't wait to the end of the case for the 4 years of divorce litigation, whatever it is, to see where the kid's going to be in the meanwhile. So receiverships is another one. Immediate possession of property, because we highly value property in this state, is another one. Class certification is another one, primarily because if a class is denied, that's usually the end of the case. If a class is certified, the case settles oftentimes. There are administrative appeals. The last one, I'm sorry for this mess here. The other area, and it's right smack in Article 5, Section 4, says that there is appellate jurisdiction directly from administrative agencies to district courts of appeal. And the main one are appeals of final agency action under the Florida Administrative Procedure Act. Probably just well enough to know that some administrative orders can go directly up. How are we doing?
Technically 10 minutes more on this subject.
10 minutes more, we can do that. No problem. Okay. The other two courts, the next lower ones, are the circuit court and county courts. We look at the Constitution. We have a text. The good thing about Florida constitutional law is you can find the answer, unlike, well, I'm not going to talk about United States constitutional law because I'm not an expert in that area. And so, Florida Constitution is what affects me. County courts. It says the jurisdiction of the county courts shall be prescribed by law. I've listed for you all of the laws right there. You can go read them for yourself. And what it boils down to essentially is that the county courts have jurisdiction. There's one county court in every county. Okay, there's 67 counties in this state. Every one county court. If you go up to Gulf County, you're going to find one county court judge. He or she's a pretty lucky, powerful person. Down here we have about 60, give or take, of one or two. The county courts are more than small claims courts, but what the main pieces, the main jurisdiction for county courts, and you can read it all through here because I gave you that and I highlighted it, so I'm probably not going to be able to go back through it, but I highlighted the provisions, so please look at it. The main jurisdiction are for cases of less than 15 claims for less than $15,000. Here it is, actions at law that do not exceed $15,000 exclusive of fees and costs. Violations of municipal ordinances, simple dissolutions of marriage, evictions are usually in county court, but the main ones, just very quickly, are cases where the claim is less than $15,000, and the other one is misdemeanors. Misdemeanors all go to the county court. They're heard there. You can get jury trials for misdemeanor cases there if there's a prison term at issue possible. The only exception, which is small stuff, is that if there's a misdemeanor combined with a felony, that gets transferred over circuit court for the obvious reason that if this county court adjudicates the misdemeanor, the odds are a pretty good chance it's going to be double jeopardy. There'll be a double jeopardy issue over here in the criminal court. So this is the county court. It's the people's court, and lots of cases, which makes it easier to know what the circuit court does. The circuit court is the court of general jurisdiction, does the heavy lifting in this state for solving people's disputes. And the jurisdiction, don't get yourself all worried about all of that. The jurisdiction of the circuit courts, again, jurisdiction of the circuit courts is in fact set forth in the next section down, you can just, there's 6 sections of Article 5 that are important. That's all you need to worry about, my opinion. Circuit courts shall have jurisdiction not vested in county courts, and jurisdiction of appeals when provided by general law. So, circuit courts therefore will have jurisdiction of cases over $15,000. Circuit courts will hear family cases, divorces. Circuit courts have a probate division, take care of wills, landlord-tenant over $15,000, juvenile cases, bad parent cases, dependency cases, all of those many things and more. In addition, the circuit court has a huge, civil is huge criminal jurisdiction, and this criminal court hears all felonies and occasionally a misdemeanor in on it with it. There's a drug court, there's a domestic violence court, all of that set forth by statute. Bond validations, remember I said that it goes directly from the circuit court up to the United States, Florida Supreme Court. So the circuit court hears it, and equitable cases. The only other piece, forget about original jurisdiction, the only other one that I want to point out to you is that we're looking at a pyramid here, okay? You start in, let's say, you start in the county court. County courts has more cases than the circuit court. If you're a disappointed litigant, okay, you get sued, you're the defendant, you get sued for $10,000 and you lose, and judgment's entered against $10,000, and you want to appeal that, you appeal to the next level up. Everything goes from one level, to the next level, one level to the next level. That's the pyramid. So in a county court, if you lose over here, you have a $10,000 judgment entered against you, or if the plaintiff and you sue for $10,000 and don't get it, or if you have a misdemeanor conviction, county courts hear all first initial DUIs, by the way. That's a lot of what they do. If you've been convicted and you want to appeal, you file a notice of appeal, and your appeal is heard in the next level up, in the circuit court appellate division. So the circuit court is the main heavy lifting trial court, but it has I'll call it little, but it's an important little, has its own appellate jurisdiction, has its own appellate court. Okay, the District Court of Appeal is an appellate court, and that's all it is. But you go up, up. So there's appellate jurisdiction there, and then you can try to go on, but you get over into the area that I'm going to have to leave to you. You go on by writ after that, okay? Much harder. As you go up, it gets incredibly hard. Remember appellate jurisdiction. In the circuit court, obviously, circuit court, just as I've already shown, the appellate jurisdiction is right there. Everybody following me? I hope. Okay. So, what's next? I told you I'm going to leave original writs to you. What I would suggest to you is that the only thing, I know I'm taking chances here when I say only, but we're trying to hit the main points. Look at page 9 of the original writs of this piece here, written by another colleague of mine, Judge Northcutt. You get this is how you learn original writs when you become a judge. Page 9, in a sentence, tells you what every original writ is. And you might just want to look at it, and you will see a definition of the original writs, which I'd had listed up there. which would be prohibition, mandamus, habeas corpus, quo warranto, and all writs. Of the five, the three to concentrate on are the first three. Prohibition commands that a respondent refrain from doing something, the respondent in this case being a court, they don't have jurisdiction. Mandamus orders a court to do something. Habeas raises the question as why does the, literally, and it's Latin, why does the government have the body, habeas corpus? Why do you have the body? That's what habeas corpus means in Latin. So if you know that, you will probably be fine. The only other point that I want to make about writs is, this is one I want to emphasize because it has been tested, truly been tested a couple of times, so I want to make this point, that if we go back to the jurisdiction of the Florida Supreme Court, what happened to me? Am I going the right way? Whoop, there we are, happened, good. Note, with respect to jurisdiction, there is no certiorari jurisdiction in the Florida Supreme Court. Remember that. See, I'm hanging from the rafters. There is no certiorari jurisdiction. It has been taken away from the Florida Supreme Court. It does exist in the District Courts of Appeal. It does exist in the Circuit Court Appellate Division that I've just talked about. And that happened back in 1980 to maintain the Florida Supreme Court, which was sort of going out of its realm. It was removed to maintain and make sure that the Florida Supreme Court didn't have any sort of real wide ability to take cases. Rather, they had to go through the prescribed manners. No certiorari in the United States Florida Supreme Court. You'll see that in the context of cases of hypotheticals where the writer is trying to take an appeal from an administrative proceeding directly to the Florida Supreme Court, or that type of thing by certiorari. Okay. All right. How we doing? Not too bad. All right. What's next on the little list here? Okay. Certiorari I've mentioned. All of these statutes, please go home and take the chart and just put it, it'll, in my humble opinion, if you take the chart and look at the chart and go look at the statute or the constitutional provisions, all of that will fall into place and you'll be in good shape. So I'm going to skip over then the statutes, if I can. Jurisdiction, maybe, let me just see if there's one I need to mention. There's one. This thing doesn't want to work. Come on. You gotta rest a minute. Doesn't want to work. What am I doing? Look, if you will. I want you to look, please, at, well, let me see if I can do this. All right. No, I want to go back. Here's one of them, okay? The last slide in the jurisdictional piece is an important one. I've talked about jurisdiction. What I didn't talk about was the ability of the state of Florida to take an appeal. The state of Florida is not a person. It is a sovereign. Theoretically, it has all the power. We know it doesn't because of our constitutions. So its ability to take an appeal is entirely statutory. Obviously, the state of Florida cannot take an appeal if they're prosecuting a defendant and the defendant wins. We have double jeopardy there. However, there are some few areas, and I've highlighted the main ones, where the state of Florida may take an appeal if it so desires. You probably simply need to know that the appellate rights of the government, the state, in criminal cases and only criminal cases, is entirely statutory in nature, and there's the statute. If a circuit court dismisses an indictment or information being a charge, the state can appeal from that. They didn't have a chance to try the person. An order granting a new trial, the state wins the case, and then the trial judge gives the defendant a second chance. That's appealable at that time. A sentence on the grounds that it is illegal, every state prisoner in this state, no matter how many sentences, how many consecutive life sentences that person may have, is entitled to a legal sentence. It is a basic principle of our jurisprudence. The granting of a motion for judgment of acquittal after a jury verdict, and suppression cases come up, okay? So that's a something that you just need to have a basic appreciation for. What's going on here, Dean? Am I trying to go too fast, do you think? Yes.
With the appeals that are going, contrasting that to federal, are we not able, because we don't have a statute, to appeal the way that this statute is allowing the state of Florida to appeal? I'm just trying to get a comparison.
For the federal?
Right.
Well, as I told you, Ms. Lopez, I'm not an expert in the federal Constitution, so I really cannot tell you what the appellate rights are of the government in the federal world, okay? I can only tell you that in the state world, that is it. At the federal world, I wouldn't be surprised. In fact, I know that in some cases they're different. I mean, I know, for example, that if unlike the state world, in the federal world, if that's okay, we can go there if it works.
It is, it's really sluggish, so I'll leave it there, but I'm going to.
Okay. We're going to take a break right after this piece. We're pretty much on time?
Yeah, we should finish at about 4:30 on this section.
We can do that. And then we'll take a 10-minute break, will we? Okay. To answer your question, it is different. I know it's different. I cannot give you the details. One way it's different is if a U.S. district judge grants an acquittal after the state's case, that is not appealable. It's over. It is appealable. It is appealable. It is appealable here, and that's caused a lot of consternation in this community. It's the only reason I know it. All right. We have spoken about all three branches of government. In fact, we've laid out sort of we did our sort of groundwork, the separation of powers. The next thing we did was we talked about the legislative branch. Two areas, and I wound some things in. The next thing we did is I wound in the executive branch as we went. Next thing we did, we spent a fair amount of time on jurisdiction because that's what we do as lawyers. We're now, can you open that for me? This man, it's a karate guy. If you can't open that, I'm not signing up for your course. You got about 40 people watching here. Of course, I spill it. We now move by about 45 degrees, if you will. We are heading to, bless you, a discussion of tax and finance. Probably the toughest article of the Florida Constitution. There is some groundwork to do before we get there. We're going to do the groundwork now and take a 10-minute break, clear your heads, and then we're going to go into the two most difficult pieces of Florida constitutional law. We're going to do tax and finance and homestead. Then we're going to go Declaration of Rights, and out for a glass of wine, I hope. That's what I work for. And so, Article 8, local government. The basis, judges are not supposed to have a sense of humor, so I don't know how I ever qualified. Local government. The point to know here, which will lead us into Article 7, the basic ground point, if you will, is that there is a hierarchy of political subdivisions in this state. The political subdivisions of the state are actually 4. The state, of course, is the sovereign. I put it up there so we have it. There are 4 political subdivisions of the state. There are county school districts, municipalities, and special districts. There is a line here, and the reason is that the status of these 2 is much greater than, let me get the words I use, than these 2. Why do I know that? Why do we know that? Lesser in status, the words I use are that municipalities and special districts are lesser in status, dignity, and sovereignty than are school districts, counties, and obviously the state. How do I know that? I know that because the state we know is the sovereign. I know that because if we look at Article 8, excuse me, I want to get this exactly right. Article 8, Section 1, first sentence says, look at your text please, the state shall be divided by law into political subdivisions called counties. That's an order by the people of this state. So they're political subdivisions because it says so. Then if you go back over to Article 9, the education article, you see much the same thing. Each county shall constitute a school district. So every county is a school district. There must be 67 school districts. All right? You can combine 2, but it's 67. That is different from a municipalities and special districts. Municipalities are defined in Article 8, Section 2. Municipalities may be established or abolished and their charters amended pursuant to general or special law. They do not have the same degree of sovereignty, dignity, or status. Similarly, special districts, which we'll get a definition of, a special district is a political is a unit of government. These are all units of government, but when we're talking about political subdivisions, there are constitutional political subdivisions of the state, which have a higher, greater status and dignity than do municipalities and special districts. These 2 are not constitutional political subdivisions. They are not required by the Constitution because, as I just read to you in Article 8, Section 2, I think it was, 2, these municipalities and special districts, which I'll get a better definition for you in a minute, can be created or abolished by whoever their creator is. With respect to municipalities, it is that the creator is the state of Florida legislature. With respect to special districts, a special district can be created by a state, a county, could be a school district, they don't do that, or a municipality. What is a special district? I'm going to hop over there to that since I'm on the subject, just so we don't leave anything uncovered. We will come to a slide shortly that says Special districts are units of local government created, listen to what I just said, same thing, by general law, that's the state legislature, special law, that's the state legislature, local ordinance, counties or municipalities, or by rule of the governor and cabinet, that's a throwaway, to perform specialized functions and services such as fire control, hospitals, and water management districts. And that's about 3 slides over. But just so you have the grounding, a special district can be formed for a particular, a special district is a unit of government formed for a particular purpose. So, most of you perhaps have heard of the South Florida Water Management District. It is made up of about a dozen South Florida counties, and it manages the water needs and water flow in its area. You can have a special district. A special district can be of any size and any boundaries. It can be what I just described. It might be a county, following county boundaries. It sounds counterintuitive. You would think you might not be able to have that, but you can. You can have a county, and counties have formed themselves into special districts for fire purposes. And they can use that special district, as we will see when we get to Article 7, to gather more money. That's the reason they do. A special district can be just a little piece of unincorporated county. When I lived out in Doral, they had a special district to take care of all the trees and swales out there. They didn't want the whole county paying for it. Fair enough. And so it goes. There are 2 types of counties that we need to know about. Okay, the next and last slide. There are 67 counties in the state. 67 counties in the state. There are a couple that have their own constitutional basis. As it happens, Metropolitan Dade County is one of those, but you will be taking a statewide bar exam, so you probably don't need to know any of the special things that pertain to Metropolitan Dade County. What it means is Metropolitan Dade County, because it's constitutionally created, has more flexibility than the others. And Jacksonville is the other one that of any moment, which is a consolidated county. I'm not going to worry about those. The 2 things you must know, because there has been a single Florida constitutional law question on these 2 alone. Okay, just these 2, is the difference between a charter county and a non-charter county. It is also textual. Most of what we do here is textual. And you look at the definitions. I have put them up here. Non-charter county. Counties not operating under a county charter shall have such power of self-government as is provided by general or special law. Most counties in this state are non-charter counties, meaning they do not have a written document. If it's a charter county, it will have a written document that is approved by the legislature and also approved by the voters. It's essentially a constitution, a local constitution for that area. Most counties don't want it that. Maybe they live free or die or whatever the reason is. New Hampshire. And so, for non-charter counties, if you read this piece, what it will tell you is, write it down and then you can go back and read it yourself. A non-charter county may not enact any ordinance inconsistent with either a general law passed by the legislature or a special law passed by the legislature. And with respect to municipalities within that non-charter county, and if there is any conflict, the municipal ordinance will control. If you have gun regulations, Broward County had this issue in the past, then the municipal law, because, no, well, Broward happens to be a charter county, but if there were a non-charter county where you could have gun laws, for example, where the municipality doesn't wants more regulation and vice versa, the rule would be the municipal ordinance would control. So, just to repeat, to be sure we have it, because this is what you have to remember. Non-charter counties, the county may not enact any ordinance inconsistent with general law, special law, or general or special law, and municipal or ordinances control. Obviously, charter counties have more authority. With respect to charter counties, the charter county may not enact any law that is inconsistent with general law. That remains. However, with respect to special laws, the legislature can only affect a particular county by special law. Think Pinellas County, the dog case I mentioned earlier. Only if approved by a vote of the people of the affected area. For example, Pinellas County. And with respect to charter counties, the county gets to choose whether or not, in the event of a conflict, the municipal ordinance will prevail or the county ordinance will prevail. I've already pointed out the fact that municipalities are different and may be established or abolished. Let's take a 10-minute break. We'll be back here at 1:15, and we'll finish. Having established the base, the groundwork, we now move into the Article 7, Tax and Finance, which is probably the most difficult article of the Florida Constitution. Every state has its own tax and finance provisions, and so we obviously talk about Florida. And what we are going to discuss here is how state and local governments raise money. State of Florida and all local governments thereunder. They do it in 3 ways. They do it through taxation. They do it through non-tax, off-text, off-text, revenue-raising methods, and they issue bonds. That means borrowing, just like you borrow to buy a house. 3 different ways. We will talk about each of them. With respect to this article of the Constitution, unlike the others that we have studied so far, all 18 sections, unfortunately, are important. Let us begin. The beginning of wisdom, and we divide the 18 in half. With respect to taxation, taxation is covered in Article 7, Sections 1 through 9. Borrowing, bonds, 10 through 18. Non-tax revenue, as I say, is off-text, T-E-X-T. So, we start then with taxation, how state and local governments can tax individuals and corporations. And let me get my notes here. Excuse me. How individuals and corporations can raise taxes. And the beginning of wisdom, as I said, is to understand the first and the last section of that portion of Article 7, which deals with taxation. 10 through 18 is bonds, borrowing. The beginning of wisdom is to understand these 2, the first and the last, first 1 and 9, and how they fit together. They fit together, folks, like a hand in a glove. And you just have to know this. You have to stare at it until we understand it. That's how I did it a long time ago. Article 7, Section 1 says, no tax shall be levied except in pursuance of law. Then it has a prohibition. There shall be no state ad valorem taxes upon real estate or tangible personal property, the desks and things like that. All other forms of taxation shall be preempted to the state, except as provided by general law. Then we go over from here to 9A, and we go from state taxation to local taxation. And we see this piece there in A that says counties, school districts, and municipalities shall, and special districts may, be authorized to levy ad valorem taxes, tax on the value of property, usually referring to real estate, but could be personal property as long as it's on the value. So ad valorem means to the value. And may be authorized by general law, meaning by the state legislature, to levy other taxes for their respective purposes, except ad valorem taxes on intangible personal property and taxes prohibited by this Constitution. Let's go back to the top and look down. What we want to look at here is what are, with these two provisions, or what is the core constitutional taxing framework in the state of Florida. First, as the people of the state who adopted this Constitution have said, no tax shall be levied except in pursuance of law. This means general law, not special law, not general law of local application, not appropriation acts, general law. But pursuance of law, can also include constitutional law. Let me back off from what I just said just a little bit. I'm sorry. I've been doing this 2 hours. We're going to get this right. You're going to follow me. No tax shall be levied except in pursuance of law. Okay? We're going to get down to general law here. Pursuance of law. What is law? That's what I want to say. What is law? Law is, can be constitutional law, and it can be statutory law. The Constitution is law. You've got to obey the Constitution, right? It is law. Or it could be statutory law. That's what that sentence refers to. So, if we want to know what the taxing power is of the state and local government, we go to two places. We look first at the Florida Constitution, and then we go to the statutes. Look into the Florida Constitution. If we look all the way through it, then you will find, as I said a moment ago, Article 7, Section 9A, which says, counties, school districts, and municipalities shall, that's mandatory, they have it, and special districts may be authorized to levy ad valorem taxes, that means taxes on the value of property, nothing else, and may be authorized by general law. General law, of course, is passed by the state legislature, to levy other taxes for their purposes, except for, then there's a prohibition or exception, that these local governments may not levy an ad valorem tax on intangible personal property and taxes prohibited by the Constitution, which would include things like state income tax and state inheritance tax, which are prohibited. So the first authorization, we're looking, where does the law allow state and local governments to tax? There's the Constitution. There's one area. And that's the only area, by the way, that you're going to find where there's an express authorization. So we've done that much. And then, at the same time, we then go back over here and we see that no tax shall be levied in pursuance of law. We have said that includes constitutional law. We've done that piece of it. We've also said that law means general law, right? two types of law. And so the state has plenary power to tax. Not a surprise, because it is the sovereign. The state has the plenary power to tax, except that there shall be no state ad valorem taxes levied that can be levied by the state upon either real estate or tangible personal property. Tangible personal property is your desks, whatever else you own, your cars, whatever else it may be. And this just emphasizes that all of these other forms of taxation shall be preempted to the state except as provided by general law. The state of Florida has the plenary power to tax. It does have the ability to delegate it, but most importantly, if it does so, it must do so by general law. It may not delegate any of its plenary power to tax, by special law or general law of local application. Why is that? Maybe this will help you remember it. The reason is that the people of this state have divided the taxation of this state into two parts. The ad valorem taxation is reserved over here to local governments. That's their main form of taxation. All other taxation is reserved to the states, and the philosophy is to maintain all of that at the state level so that each have their revenue streams, but with the exception that a state can provide, delegate, if you will, a portion of its taxing power, sales tax, excise tax, gasoline tax, all of the other taxes that it levies in this state, to local governments, provided that it delegates or gives a portion of it by general law to every county or every municipality, usually county. That's the rationale behind it. Yes, ma'am.
So can the state tax real property or personal property if it's not ad valorem? If it's like a fixed rate? Just thinking about it.
Yes, I suppose I could have a per head tax, right, Dean Singer? I mean, I don't think you're not going to see that. A per head tax on every, I don't know.
I was just concerned if
Every-
you have questions, so that's not a chance.
I don't think you're going to see that. If you go further into Article 7, I mentioned automobiles a minute ago, solely because it's a tangible personal property. There is an exemption. There's actually an exemption in Article 7, Section 1B, I think it is, that says that an ad valorem tax cannot be levied on automobiles, only a license tax, which is what you pay in this state. That's a detail. But what I want you all to do, please, is get on top of this, because we got 18 sections, and follow it. Okay. Let's continue that. So, by virtue of this, we know the state has a plenary power to tax under the Florida Constitution. They can delegate some of it, so long as they delegate it to everybody by general law. That is an extremely, extremely important point to remember. You might see that on an exam. The other piece of it over here is the Florida Constitution has provided to local governments the right to tax ad valorem, to levy ad valorem taxes on real estate and tangible personal property. Probably the governor. Can I take this? President? I need a new job. That I'll take. Mr. President, I'm too old for another job. Can't even bend down. Okay. So, Continuing on, please, with me. Took me a half a day to write this paragraph. You want to write it down? I'm going to read it slowly enough. Thus, pausing to draw together just these two provisions of the Florida Constitution, we know that, except for the express constitutional authority given by the Florida Constitution to counties, school districts, and municipalities to levy ad valorem taxes on real property and personal property, and tangible personal property. Remember, intangible property, personal property, is taxable by the state for ad valorem purposes. These local subdivisions of the state that I just mentioned, counties, school districts, and municipalities, and all other subdivisions, political subdivisions of the state, including, by way of example, special districts and water management districts, must have general law legislative authorization from the state of Florida to tax. I'm not talking about fees, tax. I've given you a definition of what a special district is. Finally, to the extent that ad valorem taxes may be levied, they may be and are in fact levied against real property, personal property, and intangible personal property, however it may be titled, whether it's owned by an individual or whether the Southeast Bank building is owned by a corporation or whatever else. The tax, this is not so important, is cast in mills, 1/10 of 1%. That's just an historical matter. But what is important, what is important?
What's an example of an intangible personal property?
Fair enough. And intangible items will be stocks, bonds, promissory notes, computers, the stuff that's inside computers. There's cases on that, some interesting cases. The best example I can provide to you is that if you go to buy a house and you borrow money on that house and you have a promissory note that you sign of, say, $500,000, that promissory note is an intangible piece of personal property, meaning that the bank that gets it can sell it, and does sell it nowadays, to somebody else. It's property. It's not real estate. It's personal property, and it is intangible because you can't, it's not a desk. And getting to the point that you just led me to, which is right where I was, that with respect to an ad valorem tax on real property and personal property under Article 7, Section 2, that ad valorem tax must always be levied at a uniform rate within each taxing unit. But with respect to intangible personal property, the limit is 2 mils on the dollar, and it does not have to be a uniform rate. When you go to close on a house, you will pay on that $500,000, 2% of $500,000, $10,000, whatever it is, and it's probably graduated up. You know, on the first $100,000, you're paying 1% and then 2%, whatever it may be. That is how that works. With respect to ad valorem taxes, it is important to remember that there are millage limits, okay? I've told you that with respect to intangible taxes, the millage limit is 2% in Article 7, Section 2. In Article 7, Section 9, the millage limit is set there in bold. Not the counties cannot tax more than 10 mils. Municipalities also 10 mils. School districts 10 mils. Lower percentages for water management districts. So there are a lot of limitations on taxation in this state, in addition to those that the ones I've just that I've alluded to, and you're going to have to kind of parse this through. There's a slide coming up on it. But there are other limitations I'll just mention right now, quickly. The state constitution prohibits an income tax. It prohibits a state inheritance tax. It prohibits an ad valorem tax on cars. It prohibits gazillions, many types of taxes, and you can just look at all of that if you want to, and should. Okay, we talked about what is intangible. And so, I think we have then gotten a pretty good summary of taxation of individuals. Going back to the point that I made earlier of the differences in status and dignity and so on between counties and school districts versus municipalities and special districts. I brought that up for this following reason. This is counterintuitive, but because of that divide, the lesser political subdivisions of the state are subject to tax on their real property and on their personal property. Sounds weird, but remember I had the line. I said the state is sovereign. Obviously what sovereignty means, that the state is immune from being taxed by any other level of government. Because I had above the line counties. Counties have the same degree of immunity from taxation as does the state. School districts similarly have, because they are constitutional subdivisions of the state, as I pointed out, have immunity from taxation. And then there are 25, there's some entities, the major entities like Department of Transportation and so on, that really form the state. But these three are immune from taxation. Municipalities and special districts are not immune from taxation. And I'm speaking now of ad valorem taxation, and only ad valorem taxation. And I'm speaking of taxation by the entities above the line to those below the line. Because the state has no taxing power for ad valorem taxation against real estate and personal property, they do not have the ability to tax the real and personal property of municipalities and special districts. The school districts do not do it. They probably could, but they do not do it. What you find, and there's been an entire question, an entire Florida Bar question on this subject, that counties which are political subdivisions of the state, which the same degree of immunity as the state, have the ability to levy an ad valorem tax under Article 7, Section 9A on municipalities and special districts. And I should say on real property or personal property owned by municipalities and special districts. With the exception, this is the test question, with the exception in Article 7, Section 3. Article 7, Section 3. Counties can levy the taxation, as I've said, except as follows. All property owned by a municipality and used exclusively by it for municipal or public purposes shall be exempt from taxation. That's this provision. They are not immune from taxation, and there's a difference between an immunity and an exemption. These entities cannot be taxed at all. There's an absence of power of anybody to tax them. Exemption, and an exemption presupposes that there is a power, and in fact there is a power to tax the property unless the property is exempt. With respect to municipalities, it is exempt if the property is if the property that is owned by the municipality in question is being used exclusively by it. Exclusively, two pieces of this, exclusively for a municipal or public purpose. The same applies to special districts by a judicially created exception. Let's talk about this one, because this is the one that has been tested. This could easily be tested. Here I will pause for an example. Consider the city of Islamorada, and consider hypothetically that Islamorada has an island, okay, that's connected by a bridge, say. And on that island, they have their city hall. They have a Chili's restaurant that they lease some of their property. They own the land. They have their city hall. They have a Chili's restaurant. They lease a portion of their land to a Chili's restaurant, and they have a marina where you can go fill up your boat with gasoline and pick up snacks and stuff, or maybe even, leave your boat there overnight or for a month. 3 different things on that island owned by them. Monroe County, hypothetically, sends a letter to the city and says, we are taxing you on all of the property, all of the land on that island. The General Counsel for Islamorada should write back and say, all right, we are not immune, we admit, but we are exempt. And the arguments being made will be that city hall is being used exclusively for municipal or public purpose. So the land under that city hall obviously cannot be taxed by the county under its ad valorem taxing authority. We're talking about ad valorem taxes. We come to the Chili's. The Chili's is a private entity, right? And they're being leased a piece of property. The land under that Chili's is not being used by a municipality exclusively for a municipal or public purpose at all. The city of Islamorada, because it is leased it out, has to pay property tax, ad valorem tax under the land. The marina is the tough one. The marina, under this hypothetical, is able to be used by the people of Islamorada and their boats and other people. You run the test. Is that area that has the marina on it, that piece of land, used exclusively by it for a municipal or public purpose? The case law goes both ways on it, and some will say yes, it is being under an expanded idea of exclusively. It's being exclusively, the public can come in and use it, and therefore it is for a public purpose. The other side of the argument is that this marina is no different than the marina down the street that is privately run, and it is not being used exclusively for any sort of municipal purpose at all, or a public purpose. You have a question?
No, I was gonna ask if it's a marina that's used by the state or ran by the municipality, then wouldn't it be a general municipal purpose?
Wouldn't it be what?
Wouldn't it be part of the municipal or public purpose if it was ran by the municipality of Islamorada?
It has to be used, not operated by. The language is used exclusively by it for a municipal or public purpose.
So if it's.
If it's being used, if it was being used exclusively, if it was a marina, at least the way I would argue this, if it was a marina that could be used only by the citizens of Isla Mirada by virtue of their living there, that to me would provide a pretty good argument that it was being used exclusively for a municipal purpose. And I would elide public into municipal. And I would argue that, just by analogy, that why should Monroe County, why should the private marina down the street have to pay the tax, and Isla Mirada, which is forming the same function, doesn't have to. Over here, you have exactly the same concept with respect to special districts. There is nothing in the Constitution about it, but it's the same concept. With respect to special districts, I told you a special district can exist for many purposes, fire purposes, water and sewer districts, water management districts, and so on. But if some of the property is leased to a private entity, then the county has the power, if it so desires, to tax it. You see that in Canaveral, the Port Canaveral. They have this huge port up there, and they have to have a gas station in there and a bait shop and stuff like that. The property under the gas station, the bait shop, is taxable by Brevard County under the same logic that exists under that particular provision. Okay. Summarizing at this point, state and local taxing power, pull it together. Starting on the left-hand side, as I've already said, Article 7, Section 1, no tax may be levied except in pursuance of law. Repeating, what is that law? Constitutional law, which is going to take us over to here momentarily. What is the other method of levy that the state has? General. I emphasize general, all caps, G-E-N-E-R-A-L. Don't forget it. Statutory law. And the state, being the sovereign, has therefore the plenary power to tax under Article 7, Section 1, unless the Constitution says otherwise. What is the otherwise? I'm not going to have time to walk you through them all, through the book, through the Constitution itself. Do it yourself when you have a chance. As I said, Article 7, Section 5A contains the ones about income tax and so on. The state has no ad valorem tax power on real and tangible personal property. It can tax intangible personal property. It also has the ability, the state under Article 7, Section 5B, to levy a corporate income tax with it under 5%, I think it is. And there are a whole host of other limitations. What that ends up meaning is that for the state of Florida, the major sources of non-federal tax revenue, I speak here not of the Medicaid money and stuff like that comes in, but the billions that come in from in-state, the major sources of state tax revenue are sales taxes. We pay 6% in some places. In some places, by virtue of a general law, we pay 6.5% for various purposes. Gasoline taxes, cigarette taxes, excise taxes, taxes on intangible personal property, and corporate income tax. In contrast, local governments have limited power to tax. Ad valorem taxes that we've discussed extensively. We've defined an ad valorem tax. Ad valorem tax is limited to the value of real and tangible personal property. Importantly, they must be levied at a uniform rate. if I have a house on the south side of the Broward line, and Ms. Lopez, who used to be here, who was here a little bit ago, has a house on the north side of the line, those two entities they're different taxing units, and they can tax at different rates. And then with respect to local governments in particular, there are lots and lots of exclusions or exemptions. Motor vehicles, I said, there's a $25,000 common extension. There's a Save Our Homes exemption, which has been tested. That provision you can take a look at. If you look at it from the top, what it means, what it says is that with respect to the value of real property, residential real property, that the value, there's a limit of 3% as to how much the value can be pushed up by the tax assessor every year. That's it in a nutshell. And the reason for that is back in the day when prices were going like that, people were losing their homes, so they put a cap on it. And also there are the millage caps of overall taxation that I discussed. There is a summary. We now go on to something that is very important as well. Excuse me, we're going to have to do this piece quickly. Because of all these limitations on the local government side, there are off-text methods by which local governments generally, usually, the state government does little of this, but local governments get additional money. That is by impact fees, special assessments, and user fees. Probably these two are the ones, well, it's user fees. There is no constitutional prohibition on a state or local government charging a reasonable user fee. When you go down to the courthouse to file a complaint, you're going to pay $300 or $400. You seek to have a corporation made recognized out of Tallahassee, you're going to pay a fee. These are fees that you can either pay or not pay, use the service or not use the service. That's what a user fee is. An impact fee is a one-time charge, and it is levied by local government to get a building permit. And because it is an impact fee, the law requires that there be a reasonable connection between the need for the capital facilities that will be built by all of these fees that are collected and the growth generated by the population that will result from the construction. And the money must be spent, number two, the money must be spent and collected for the benefit and spent for the benefit of the area from which it is collected. Remembering that there must be a constitutionally permitted authority to tax, okay? There must be. The challenges to these types of off-text charges are that they are not constitutionally permitted or authorized under Article 7, Section 1. If they meet this requirement, they pass muster because they are not an unconstitutional tax. Similarly, if there's a special assessment, which is a recurring charge, then and meet these two requirements, then similarly, even though it is not authorized, an authorized tax under Article 7, Section 1A or Section 9, they pass muster, okay? I'd take a look at those a little bit more carefully when you have time. Lastly, I think we're lastly, but importantly, we talk about borrowing. The state and local governments can borrow money, but it is very substantially restrained, so the legislature can't just go up there and borrow a whole bunch of money and burden the state and come home. There are three areas, money can be borrowed by the state of Florida, can be borrowed by all local governments, including special districts, and that can be borrowed for economic development projects. We now go to Article 7, Section 9, or 10 rather, and we look at the first line, which says, pledging of credit. Remember I said 1 through 9 is taxation. Now I'm going to borrowing, which is pledging of credit. And says neither the state, you start with this provision, neither the state or county, school district or municipality or special district, neither state, county, municipality, special district or school district, shall become a joint owner with or stockholder of or give or use its taxing power or credit to aid any corporation or person. The government is prohibited from engaging in private businesses with others. The government cannot invest in the Ryder Company or whatever else is around, the Harris Corporation, whatever else is around. The government has to be, when it borrows money, it has to be for a public purpose or a paramount public purpose. One of the two. With respect to state bonds, the state can issue what are known as general obligation bonds. Pursuant to Article 7, Section 11A through C, the state bonds borrowing provision is found in Article 7, Section 11. They can borrow money, pledging the full faith and credit, but only to finance the cost of fixed capital outlay projects, meaning buildings, roads, things of that nature, and also only if approved by a vote of the electors. In my lengthy lifetime, I have no recollection of the state ever doing that because the legislature would get thrown out probably. They don't want to have to vote more money for themselves. And there are some exceptions for recent times for pollution control, acquisition of property for roads and bridges. But the basic proposition is right there. General obligation bonds, which pledge the full faith and credit of the state. That means putting the public fisc at risk, is the way I state it in class. Putting the public, if the public fisc is at risk, that's pledging the full faith and credit. If the public risk is at fisc is at risk, then there has to be a vote. So the legislators are not just up there giving away all your money. There are also revenue bonds that can be issued by the state. A revenue bond can only be issued also to finance a capital outlay project, but a revenue bond does not require a approval of the electors because a revenue bond is repaid by whatever that capital project is. Best example I can think of is the Florida Skyway over there that goes from St. Petersburg, Pinellas to Tampa. That thing was built with revenue bonds. That bridge was built. You pay $2 or $3 to go over it. The people who bought those bonds, because they're sold to the public, bought those bonds, their only source of recovery is money coming from that bridge. That's to distinguish it from general obligation bonds. Going from state bonds to local bonds, we have a similar provision, Article 7, Section 12. Pause to look at, if you would, these provisions and see how they work. Article 7, Section 10, the first of the bonds provision prohibits the government from getting in bed with any local corporation or person or partnership and so on. Article 7, Section 11, the next one, provides the limitations on state bonds. And all three of these limitations are set forth in the various subsections of Section 11. We now go to local bonds, which is the next section, Section 12. All of this kind of runs pretty logically. And with respect to local bonds, says counties, school districts, municipalities, special districts, and local government bodies with taxing powers may issue bonds payable from ad valorem taxation. That's the big point. Only to finance capital projects and only when approved by a vote of the electors. Remember that I've said that the ad valorem taxation provision, Article 7, Section 9, is the main funding source for local governments. It is the equivalent of all of the sales tax and so on for the state. Because therefore, if the local government, whichever the four, is borrowing money, it is limited to borrowing money and pledging ad valorem taxes. It is limited to using that money can only be used to finance capital outlay projects, as I've already said. And just like general obligation bonds, voter approval is required. Why is that? Because the public fisc is at risk. If you put the ad valorem taxation base of local governments is equal to the full taxation base of the state of Florida. The public fisc is at risk, and so those are analogous. If the public fisc is not at risk, then no voter approval is required. So those two are parallel to each other. This one, state bond, general obligation bonds, and local bonds where ad valorem taxes are pledged. Lastly, and this one has had its own test question, industrial revenue bonds. Industrial revenue bonds are economic development bonds. And they, as distinguished from all other borrowing, have the permitted use of incenting private projects, bringing economic development into the state, because every state competes with every other state to bring in industry. Article 7, Section 10, if we go back to it, prohibits that, and except, with the exception of 10C, that says the issuance of and sale by any county, municipality, special district, or other local government of revenue bonds for airports and port facilities, manufacturing and industrial facilities, and then government economic projects. Other than that, it permits that, provided in the case of industrial and manufacturing facilities, the bonds are repayable from the project, and the interest is exempt from federal income tax with respect to any type of economic development other than an industrial or manufacturing project, the Publix distribution center up in North Florida on I-10, if you've been by it and noticed it, is one example. It's not an industrial and manufacturing project. It's a big, huge distribution center for all the South. Where the bonds are payable from the project and the interest is tax exempt, they are lawful. And if there's no public backup, public tax backup, then they only need to meet the public purpose test. If there is a pledge, a backup pledge or guarantee by the local government to get that project into Florida, then there must be a paramount public purpose. The points to remember here, the way to look at this is, remember state bonds and local bonds. The analogy between general obligation bonds, where the public fisc is at risk, okay? Revenue bonds, you're not really all that likely to see. You are very likely to see an industrial revenue bond question. And if you see it, the way you will know that you need to be talking about industrial revenue bonds instead of state or local bonds is a private project. So when you get to the question, one of the first things, probably the first thing to look at is, do you have a public project? You're building a state office building or addition to the turnpike, or a local project, whatever it may be, or do you have a private project? Private projects can be financed in very, very limited circumstances, provided that the conditions are met as I've set forth. Homestead. Article 10, Section 4. Also tested. Okay, Article 10, Section 4, we're going to look at the text. Article 10, Section 4 protects the family. That's the whole idea of it. And it exists for four purposes. With respect to the home that an individual owns, it provides a lifetime exemption from claims of creditors. Let's call it the MasterCard company that has a $25,000 judgment. They can collect on any of the assets that you have, but they may not execute on your home if that is your homestead. Upon your death, there is an additional exemption as against your creditors, provided that the property goes by devise or intestacy to a spouse or heirs, including minor children. Then there's a limitation on devise and a restriction on it. Let's run through all four. We go to the text, and the text tells us that there shall be exempt from forced sale. What is a forced sale? The most prominent one, of course, is a final judgment on which the MasterCard company seeks to execute, and they use the government to execute. They use the judicial branch, the sheriff. That's a forced sale. There shall be exempt from forced sale under any process of court, with the exception of payment of taxes and assessments and obligations contracted for the purpose, improvement or repair thereof, or obligations contracted for house, field, or other labor, the following property owned by a natural person. That's the homestead property. This sentence exemption from forced sale. The sheriff can't go pick up your homestead if it qualifies. We're going to find out what qualifies in a moment. Except that the sheriff can execute on that $25,000 on the sheriff can execute on any judgment or judgment lien for the payment of taxes, federal, state, and local taxes. Obviously, you got to pay your property tax. That's what that's all about, and related assessments. And there's an exception from forced sale for obligations contracted for the purchase of the house. That's your mortgage. You can't not pay your mortgage. Or if you have your house repaired, you must pay the materialman, you must pay the labor, and so on. Otherwise, for the MasterCard company or for the car loan company or so on, they can't, or if you just have a loan and they get a judgment against you, a common ordinary loan, your property, because it is your family, cannot be, is exempt. And it applies to a homestead, so we know that it applies to real property and to personal property up to a limit of $1,000. So what type of property can qualify? I've just stated what can qualify. Real property and personal property up to $1,000. That's the type of property that can qualify. What must an owner do? How do you know whether or not that owner can qualify? If that owner qualifies, by the way, and the MasterCard company comes in and seeks to take the property, you file something in the courthouse. A notice. There's a statute that shows you how to do it, and that stops execution on the property, and then you go through a process. So, we know what type of property can qualify. How do we know whether or not it is homestead? That property is homestead if it is owned by a natural person, not a corporation or partnership or anything like that, owned by you and me. That natural person must either make that piece of property, his or her homestead must be living there, or intend to live there real quickly. Must be on his or her way there, essentially. Make it his permanent residence or intend to make it his or her personal residence. The third requirement, there are three requirements in order to prove that your property is homestead. As I say, you file the notice and then you have to go into court and prove it, but you stop the execution in the meanwhile. The property must meet the size and contiguity requirements of Article 10, Section 4A, or $1,000 in the case of personal property. With respect to the size and contiguity requirements, it is a little bit tricky. And with respect to, let me get back here. Excuse me. Actually, I think I'm going to go here. Just go back to text. Yeah. Go back to text. And if that property is located outside of a municipality, then if you have your residence on that property, that property, even if your residence is just in a little corner of that property is protected up to the extent of 160 contiguous acres. You can't have 40 acres in South Dade and 60 acres in North Dade. Up to 160 acres of contiguous land and improvements thereon. With respect to the 160 acres, so long as it's your homestead, I don't want to get too far afield here, but you can put other stuff on it. It has to be your homestead, but you may also have a Marriott on it, actually. but it has to be your homestead. If your homestead is on that property, usually you'll have a cornfield or something like that, but you can have a business on it, is what I'm saying. And with respect to property outside a municipality, cannot be reduced without the owner's consent if some of that 160 acres happens to be annexed. If that property is inside a municipality, the exemption applies only to 1/2 acre of the land, which, unlike the outside concept, shall be limited to the residence of the owner's family, owner or owner's family, meaning that, unlike what I just described, for the 1/2 acre, if you have your house on a 1/4 acre and you have a fruit stand, let us say, on the back half of that property, the exemption is, because the exemption is limited to the residence of the owner or the owner's family, only the 1/4 acre is exempt. There's a lot to that paragraph. You have to go, if you wish, and read it. Finally, the ownership interest that I've been talking about is not limited to a fee simple interest. It can be any type of interest. A life estate, for example, in a 1/2 acre inside the municipality, as long as it otherwise qualifies, is exempt. It terminates, homestead terminates on the death of the owner, and the reason for that, quite obviously, is that the property has to be owned by a natural person. Once you're dead, you're no longer a natural person. And of course, if you sell it. Upon death, importantly, we get to section 4B. 4B. Upon the owner's death, the homestead character of the property ends. That's a critical point. That natural person is no longer there. One of the 3 requirements for property to be homestead no longer exists. Nevertheless, the benefit, this is the hard concept, the benefit that the decedent had, meaning the $25,000 MasterCard judgment that the decedent had against him or her at the time of his death, that exemption inures, that's what the word inures to, can be claimed by the surviving spouse or heirs of the decedent. It's not the debts of the heir that gets the property, but rather it is the benefit that the decedent had. The idea is to push the property alone. Who is an heir? An heir is anybody as defined under the Florida intestacy statute. Therefore, it becomes a real problem for a judgment creditor, that $25,000 MasterCard company, and so on. 2 other features that are important, going back to the provision itself, is a property may not be devised. I'm not talking about intestate possession here. May not be devised if that property is owned, if the decedent is survived by a spouse or minor child. If so, the devise is invalid. What happens when a devise is invalid? You go into the Florida statutes, and the one in question is, the one that's important to remember is right there. Please read that. In the event a piece of property is not devised as authorized by law, meaning the decedent is survived by a spouse or minor child, then the property is not divisible under Article 10, Section 4. The property becomes intestate property. You go to the laws of statutes of intestacy, and you just follow it. If not devised as authorized, the homestead shall descend in the same manner as other intestate property. But if the decedent is survived by a spouse and one or more descendants, that's not just minor children, descendants, broader concept defined, the surviving spouse shall take a life estate with a vested remember to those descendants, the minor children and other descendants, living at the time of the decedent's death, but there's another alternative here that in lieu of the life estate that the spouse might get, the spouse can elect to take an undivided 1/2 interest in that homestead property. This provision is new. You should know both of these, and it could be tested. Finally, of course, if you're married, you got to get your spouse's consent to sell your property or mortgage it. We will now talk about Article 1 of the Florida Constitution. This one is something which should have some basic familiarity to by virtue of Florida constitutional law. I'll cover just a couple of them. First, look at Article 1, Section 2, if you will, with me. Look at the chart. Article 1, Section 2, basic rights. There are 3 in basic rights. All natural persons are equal before the law and have inalienable rights. Number 1, that's the Florida Equal Protection Provision. And shall have the right to acquire, possess, and protect property that, together with Article 10, Section 6, and Article 1, Section 2, is the private property rights provision of the Florida Constitution. And then 3, no person shall be deprived of any right because of race, religion, national origin, or physical disability. That is called the deprivation clause, obviously, of the Florida Constitution. And importantly, all of these protections apply against only state action. There's your case. We conclude that there was no intent to expand this section to protect it against private conduct as well as government conduct. So the deprivation clause, for example, does not apply to discrimination of a corporation to an individual or disability inflicted by deprivation due to disability inflicted by a corporation against an individual. There are all sorts of other laws, federal and state, that handle that problem. In addition, Florida has, very much like the federal government, but not exactly, 3 levels of scrutiny that apply to these basic rights. Strict scrutiny applies to protection of fundamental personal rights, and by that I mean personal rights, has a definition, or not in the Constitution, but a definition. Personal rights are race, religion, physical disability. There's no provision in the Florida Constitution for historical reasons about gender, sex, that sort of thing. But if there's a claim that a government agency, government entity discriminated you against one of those grounds, then whatever the government did is going to be subject to the strict scrutiny case that you know about. Similarly, under the Right to Privacy Clause, Article 1, Section 23. Florida also has a heightened scrutiny test. You don't see it a whole lot, mainly in the area of commercial speech, or some areas where strict scrutiny probably is not a good idea, such as schoolyards. Otherwise, you have the rational basis test that applies. A couple of other areas to know about. Article 1, Section 23, access to courts. This is not a personal right. It may sound like a personal right, but it is not a personal right. It's a right to access to courts. It's not like race, religion's not the same level. You need to know the test, and this gets tested as everything that I've been talking about, I guess, most everything. There's the provision. The court shall be open to every person. Does not exist in the United States Constitution. Provides greater access to courts. The test set forth right here. And this is the main case, by the way. Where a right of access to courts for redress of a particular injury has been provided by statutory law predating the adoption of the 1968 Declaration of Rights, that's the current Constitution, or where such right has become part of the common law pursuant to Section 2.01 of the Florida statutes, the legislature may not abolish such right unless it provides a reasonable alternative to what it's abolishing or demonstrates an overpowering necessity for the abolition of that right. Here's my example. Medical malpractice. Let's assume that the Florida legislature wanted to pass a law, which it has, that says that after 8 years, you may not sue for medical malpractice, even if you didn't know that the sponge was inside you until year 9. Okay, doesn't sound fair, right? Statute of limitations, statute of repose is called, precluding it. Okay, so you sue. The doctor or hospital comes back and says, no, that statute of repose is constitutional. The plaintiff says, that statute of repose is unconstitutional in 9 years because I didn't know. I didn't have any access. You run the test. Where is it? Did the right exist by statutory law, the right of medical malpractice exists by statutory law predating the 1968 Constitution? The answer is no. It's common law. Medical mal is common law. Or where such right became a part of the common law pursuant to Section 2.01 of the Florida statutes, which is the initial law of the state, way back in 1845 and before. The answer to that is yes. The answer to that is yes, because in Old England, if whoever it was that did medicine in those days malpracticed, there would be a cause of action. So running the test, because they're, go back. Don't tell me this is going to quit on me. I think it's getting tired. Running back. Okay, running the test. Where right of access has been provided by, in this case, common law, pursuant to the statute before 1776, the legislature may not abolish the right of access, the 9-year point, unless it provides a reasonable alternative. It did not in this case. But in the preamble to the statute, they demonstrated an overpowering necessity. They wrote out that if we don't do this, all the doctors are going to leave and the hospitals are going to close and that sort of thing. And the Florida Supreme Court, not in this case, but in a subsequent case, said that's fine. So access to courts has a test. Finally, and almost finally, right to privacy is an important one. There it is. We have our own right to privacy statute in this constitutional provision in this state. The basic provisions are set forth here. Provide, just like Article 1, Section 2, only against state action. Okay, I can't sue you and you can't sue me for a violation of a right to privacy. The level of scrutiny, because it's a fundamental personal right, is strict scrutiny. There must be a reasonable expectation of privacy. I cannot, there's a case on this, I cannot well, there must be a reasonable expectation of privacy. We have the case of dancing women back in the bar, that sort of thing in the back, getting arrested. That, they didn't have a reasonable expectation of privacy. They could get picked up by the cops and did, okay? It's a little longer than that. The story's a lot more fun to tell, but that's, we don't have the time. And B, if there's a reasonable expectation of privacy and only, and only if there is, then we go to the compelling interest test, the strict scrutiny test. Burden of proof shifts, as I say. And this provision, Article 1, Section 23, does not provide, there's no damage action in there. Article 1, Section 18, just know that with respect to administrative penalties, that you can't use the administrative process. It's a separation of powers piece. You cannot allow, the state legislature cannot allow administrative agencies to award compensatory damages, punitive damages, or attorney's fees. There's a limit to what administrative agencies can do, primarily cease and desist orders. If you get over into, as I said, compensatory punitive damages and fees, you are then in separation of powers land, okay? And I think lastly, it'll go there. I think this thing wants a glass of wine, just like I do. The last one is Article 1, Section 12. You've got it on your chart there. The only reason I put it in there was twofold. Number one, search and seizure is, search and seizure. Every other criminal case is a search and seizure case. Wasn't me, that sort of stuff. And there's a linkage provision in there. Look at the pieces you've got before you. The article, our Florida search and seizure piece is, there's one too. Our search and seizure piece has a linkage provision in it to the United States Supreme Court, and only the Supreme Court interpretation of the Fourth Amendment, not district courts, not United States Courts of Appeal. And the point being, whoops, we're not there yet. The provision only forces a linkage between the federal and state law where there's controlling precedent. The black piece right there. That's what you need to know. And the only other one is, going back, if I can get there, we have a right to work law in Florida anytime, in any case, any hypothetical. You see, I guess you can do Article 1, Section 9 on your own. We have a right to work law in this state, and anytime in any hypothetical that you see on the bar exam that says union people are or are not excluded, anything like that, you're going to remember that the right to work shall not be abridged. And due process, I think you know about, and my puppy dog wants a glass of wine. Good luck. I'll stay around if anybody has questions.
And remember, folks, that after you're done asking your questions of Judge Shepard, we have food outside now. It should be ready. The barbecue is set up, so please stop by and enjoy some food. Next session is next Friday, all right? We're going to do Florida evidence and family law. And we're going to do a Florida common law essay to go through some of the material that Judge Shepard discussed today. So thank you all, and Judge Shepard.
Thank you, Judge Shepard.
Thank you, Judge.